We're here this morning to hear oral argument in the case of Gage Peters, appellant, versus Dennis Quakenbush and Lisa Reagle, appellees. Counsel for the appellant, Mr. Peters, will argue first. It's a civil transfer case. Transfer has not been granted, so that will be the first issue to be decided by the court. Representing Mr. Peter at counsel table, we have Kara Winicky. Good morning and welcome, Ms. Winicky. Representing the state, we have James Barta. Good morning and welcome, Mr. Barta. And also have Adam Wilford. Good morning, Mr. Wilford, and welcome. Counsels, we have been conducting oral arguments. You'll each have approximately 2 minutes before we may start asking questions. Counsel, you ready to proceed? Ms. Winicky.
Thank you. May it please the court, with your permission, I wish to reserve 5 minutes for rebuttal. In 2013, Mr. Peters was convicted of an offense in Illinois that would be akin to sexual battery here in Indiana. A collateral consequence of that conviction included a requirement that he register as a sex offender for 10 years. All 50 states have an offender registry, and all have provisions like Indiana that tracks even out-of-state offenders like Mr. Peter with their convictions. Thus, we have a system in the United States that continuously monitors and tracks these offenders as they move and travel throughout the country. In Indiana, we have 2 of those provisions, and they're both found in Indiana Code Section 11885. When Mr. Peters moved to Indiana from Illinois, he fit under both of those provisions, subsection A, subsection B1. But in October of 2023, after he had registered faithfully for 10 years, he no longer fell under either of those provisions. Another state's requirement to register is irrelevant under subsection A. Instead, that just looks at what is Indiana's requirement and whether or not it has been met, which Mr. Peters did in October of 2023. Illinois' registration obligation is relevant, however, to subsection B1, but he had no present obligation at that point to register in Illinois. He had already fulfilled that obligation. And because he was not living, working, or attending school in Florida, he had no obligation to register there either. In this case, the Court of Appeals misread the plain language of the statute. The other jurisdiction applies when a person is currently or is required to register, which in Indiana means is currently required to report in person to local law enforcement and give them certain information. That means it's a current requirement. So if you don't live, work, or attend school in Florida, there is no requirement at that point to report in person. And I don't think the state disputes that he has no requirement to report in person in Florida. And he has no collateral consequence of a Florida conviction that would attach a requirement there either. He did have that registration requirement in Illinois when he moved to Indiana, but he has satisfied that.
If Florida statute was different, and I even went to their page and looked at their FAQs that says that you don't have to register once you leave, and there's some case law on that. If they did say once an offender, always offender, you have an ongoing, if you ever visit Florida, you've got to come back every 6 months and register in person, what would your argument be?
My argument would be weaker. However, we would still look at Indiana law and what does Indiana law say, because that's where he lives. And Indiana law says is required to register.
Let me give you this argument. I'm going to ask Mr. Barta the same question. If you take the state's argument to its logical conclusion, let's say that your client was an Indiana offender and that his duty had expired 3 years ago to report. The fact he would go to Florida, the way the Florida statute's written, you still have to register in Florida because you were a past sex offender, correct?
Yes.
And then you'd have to come back, even though it had expired, you'd have to come back and register in Indiana. You would never lose it.
Yes, and you'd have to do that in any state that has a lifetime requirement, because almost all of them have this substantially similar.
Why isn't this so why aren't you, with looking at this super technical is means that 72 to 7 days, 72 hours to 7 days that you've got to register in Indiana. Why doesn't that just swallow the rule? I mean, what cases would be left out of the substantially similar? I mean, the state makes an argument that Indiana will become a haven.
That's a good question. It would almost cover everything. Where I think subsection A might apply, that maybe
substantially similar would still apply. If you worked here, had a house here, or went to school here, it would still apply.
Right. So the only reason I think one of the primary reasons I think we have a subsection B1 when we already have a subsection A is, Mr. Tyson is a perfect example. He wouldn't have to register here under subsection A, but he has a registration requirement from his home state. And so that's what I think B1 was meant to cover.
Miraquin added a requirement saying that you've got to have that independent requirement from Indiana. That doesn't fit with your textualist argument here, does it?
Well, I think the Court of Appeals used different language than I would use. So with the independent requirement, I don't think that the Court of Appeals in Miraquin added anything. I think they were simply using independent requirement to express what I call a collateral consequence,
But that's not in the statute.
It's not in the statute, except that when you read it, there is no requirement to register. Mr. Peters doesn't have to register in Florida. And so the only reason that he still had to register in Indiana because of the Illinois conviction, he fell under both those provisions. But him leaving Illinois back when he did, at first, let's pretend we didn't have subsection A at all. Him leaving Illinois, he still has a requirement as part of his sentence, a collateral consequence to register for 10 years.
If India's statute was changed from is to was, what would your argument? You'd lose.
It would be a much weaker argument.
Well, I don't see that you'd have an argument.
The difficult part would be, was required...
Maybe constitutional?
Yeah, because then it would be never ending. Anytime
what is the constitutional argument? If you're saying that you visit Florida for 3 days, and it'd be like saying that if you ever owned a car in Indiana, you have to pay the B&B license fee even though you moved to another state. I mean, what's your argument that Florida, based on a couple-day visit, can continue to monitor, if you got to come and pay $100 every July 1 and January 1 because you had visited here as a sex offender?
Well, possibly the argument would be a jurisdictional one. Would Florida even have the authority to tell?
Is there a constitutional argument there?
I think there could be, yeah.
What would it be? Can a state continue to regulate the behavior of somebody that does not live in that state and require costs, fees, and...
Not in your scenario, no. This is what's interesting about the registration requirement, is it's a little bit different in the law than other things that we have. Mr. Peters doesn't deny that he had a 10-year registration requirement from Illinois, even though he didn't live there, because that carried with him through with the conviction, almost like a sentence would. The difference is, though, let's say he had lived in a state that didn't have a registry during that 10 years. That wouldn't mean that he didn't have to register. He would just stay on the Illinois registry and register through them. This is a little bit different because the only thing Florida can hang its hat on for him to have to register there is when he's actually physically there and for a certain period of time. After that, there's no other requirement. If we're going to expand it in this way, then it could just be maybe the prospect of him wanting to travel somewhere could be sufficient to make him have to register.
Were you just saying that the convicting state can also have a continuing registration obligation once the individual no longer has any connection to that state? So here, for example, Illinois.
During that time period, yes. So when Mr. Peters was registering in Indiana, he registered in Illinois. He was on the registry in Illinois. They just simply used your registration information from Indiana.
But I thought your argument in your briefs was making a distinction between a duty to register to show up in person versus your information just being maintained on a website. Did I misunderstand that distinction?
No, so he has a duty to register to report in person. If you look at Illinois law, it doesn't say you have to report in person to an Illinois law enforcement authority. It just says to a local. So the duty to register derives from that conviction, but where you register is based on where you live, work, attend school. So him registering in Indiana covered his duty to register as a result of his Illinois conviction.
Ms. Winicky, the Court of Appeals opinion drops a footnote and says that your client apparently first sought administrative relief before the Department of Correction, but that there was no action taken, apparently. Is there an exhaustion issue in this case about whether judicial relief is available before the DOC has provided all the relief that might be available?
There's been no case law to say we have to exhaust that remedy. My client tried to and has never heard back, and unfortunately...
What specific relief did your client seek from the DOC?
He sought the exact relief that he's seeking here. He sought for them to remove him, to realize that his registration is only for 10 years based on his Illinois conviction instead of it being for a lifetime.
Presumably the sheriff of Hamilton County would not be a party in that administrative proceeding, is that right? It's simply against the department?
Well, the proceeding requires you to start with the sheriff, so you have to file something with the sheriff, and then it's sort of like an appeal. If the sheriff doesn't answer, doesn't give you the answer that you want, then you've got to go up to the DOC in Indianapolis.
Yes, I guess what I'm struggling with is whether or not even the filing of an administrative proceeding before DOC was required. He did it to no avail, apparently, or at least it's still pending, but having gotten no relief that way, he then went to court and filed a declaratory judgment action, is that right?
Yes. Attorneys that practice in this area do instruct clients, hey, you should try the appellate process. It's interesting, or the administrative process. It's interestingly worded. It's not clear whether it would cover such a situation as this. But usually if you reach out to the DOC, one of the registration coordinators, they'll ask you, have you tried our appeal process?
And do you happen to know, is there a statutory provision that governs that process?
Not that I'm aware of. The only thing I'm assuming is it's maybe through their administrative process of passing rules. I don't know of any statute. I did want to address the Ammons case, because I know that the Court of Appeals in our case relied upon that to say, we're restrained by Ammons. And the only thing I would point out is that Mr. Ammons didn't raise this argument. Now, the Court of Appeals suggested that it was covered by this court's opinion because of judicial restraint. But if it's never been raised, that's an assumption that I don't think can be made. If Mr. Ammons had raised it, it's not clear whether this court would have ruled against him there.
Counsel, leaving aside all the apparent unfairness of all this, the Florida Department of Law Enforcement, their database shows that Peters' status is listed as released subject to registration, and then later it says still required to register in accordance with Florida law. Doesn't that mean that under our statute he's still required in another jurisdiction?
Well, that's
just the plain meaning of the statute.
But if you look at the actual, so that the registry says that it has that definition under a category that they assign to registrants. But if you look at Florida law, no, he's not required to register there.
So is it your position he's only required? He registered, right? And he registered for life, but then he left. So is it your position that's extinguished at that point and it doesn't kick back in until he goes to Florida again? And then he'd have to register again in Florida?
Here's my position. Our position is if he moved to Florida and decided to live there for 50 years, yes, he's going to be under Florida law because they have a subsection A that's similar to ours. That he wouldn't be registering in 40 years because of the Illinois conviction. He would be registering, because of the other jurisdiction provision, he'd be registering because he has a substantially similar.
So why does the temporal length have any impact on that analysis? If he went back to Florida and he'd have to register for life, and he stayed there for 2 years, is it your position that if he then came back to Indiana, he would not be subject to a registration requirement under our statute that seems to encompass 50 other state statutes?
Yes, because we would go under Indiana law, which is the only reason that he had a registration or registered in Florida was because he was there, lived, worked, attended school.
Isn't that the language of the statute? Florida law defines a sex offender as a person who, quote, establishes or maintains a residence in the state.
Including a temporary residence, yeah. And so as long as you temporarily reside there,
You're a sex offender, and you have a duty to register.
You have to register. But once you leave, you deregister and you return back.
But where does it say? I understand the fundamental fairness of that approach, but where does it say that? That once you leave, you have deregistered?
Well, because then I believe there's a provision in the Florida law, similar to Indiana, that when you leave the state, when you change your address, your residence, you have to report that to Florida. And then Florida lets wherever you're going know, hey, he's on his way there. So again, it's this tracking system so that no one's dropped out, so to speak.
Good morning, Mrs. Wenicky. If we read the Indiana statute as you'd have us read it, would there be any provision under Florida law for your client to go back to Florida and seek some redress to get himself off the registry?
They have a provision in Florida to remove offenders from, or to not require them to register, except Florida, if he returns to Florida, they're going to tell him, we're not making you register. You're registering because you live in Indiana, and Indiana's making you register. He's in this sort of endless cycle.
Well, that's what I mean, though, is part of the problem that he's not able to, because of the Court of Appeals decision, he has this reporting requirement in Florida because he still has this reporting requirement here. But if, in fact, he were relieved of that, and we said, no, it was, in fact, a 10-year Illinois, and this was just a function of you going on a vacation to Florida, and we read the present tense as you suggest, that he would have some ability to remove that requirement in Florida and get out of that endless cycle.
Yes.
All right, thank you. We'll hear from you again on rebuttal. Mr. Barta.
Chief Justice, and may it please the Court, Peters is required to register as a sex offender in Indiana because he is required to register in Florida. Peters' decision to leave Florida does not absolve him of the registration requirements that exist in that state. We know this for two reasons. First, Florida requires sex offenders to maintain their registration for life unless they qualify for removal of the requirement to register. And while Peters may one day qualify, he is not qualified yet. Second, if Peters crossed into Florida again, he would not be treated as a sex offender who has never before set foot in that state. Rather, he would have to fulfill the reporting requirements that apply to offenders who have already been required to register for life. In arguing he has no Florida obligations, Peters confuses the existence of a registration requirement in Florida with whether that requirement requires present action in Indiana. Adopting his position would require this court to jettison what it called the plain language of the other jurisdiction provision in its ex post facto cases, and would gut the other jurisdiction provision by allowing anyone to move to Indiana and claim that they no longer have a requirement to register in the state they just left.
Mr. Barta, since we're talking about the plain meaning of the provision, last time you were before us in the American case, we spent a lot of time talking about is, what does is mean, past tense requirement, present tense requirement. On further review of the statute in these cases, it seems to me the better question is not what does is mean, or what's the tense of that section, of that sentence in 5B1. Really where the action is in the verb to register. Now, for good or ill, the legislature in Section 4 has defined register not simply for purposes of Section 8, which is what it takes. If you have to register in Indiana, how must you do so? You have to do so in person. You have to provide a litany of information. But that provision applies not just to Section 8, but it also presumably applies to Section 5, because it says, for purposes of this chapter, register means. Now, register is not defined in Section 4 as the general language dictionary the common sense definition of register. It has a very narrow, precise, specific definition. My question for you is, how is it that Mr. Peters, Ms. American, or any of these other folks who are subject to the other jurisdiction requirement, at least that the DOC says is subject to that requirement, how is it that they're required to register in another jurisdiction when register has this incredibly narrow meaning, which is report in person to a local law enforcement authority and provide the information required by Section 8? Does Florida have the exact same requirements as under its registration provision that we do under Section 8? I can't imagine that they do. There's got to be something other than pure identity of what's required. And if they're not the same, he's not required to register in Florida at all for purposes of 5B1, is he?
Yeah, so two responses, Your Honor. So first, I think what you're getting at, it actually may be a reason to say that the very technical definition of register is not carried through when we're talking about register in another jurisdiction, because obviously another jurisdiction wouldn't necessarily even have the same structure of Indiana where there's county sheriffs and so on.
I agree with that, but how do you get around the plain meaning then? I mean, the plain meaning of Section 4 is that it defines register, this very technical term register, not for purposes simply of Section 8, but throughout the chapter. And that chapter, for good or ill, includes Section 5. Isn't that a problem for those of us, for us textualists who think we know what the legislature meant, but they didn't say what they meant?
So I don't think so, Your Honor, for a couple of reasons. First, I think you have to read that word register in the broader context of the sentence, which is specifically register in another jurisdiction.
You say it's ambiguous then?
I think in that very specific, in that phrase,
that's yes. Then
yes. But I think a tiebreaker, which really can help the court, is that since the other jurisdictions provision's inception in 2006, it has been consistently applied not just by the department but also by the courts as meaning if you are required to register in another state, that obligation transfers to Indiana. And far from expressing dissatisfaction with that reading, the legislature has not changed the provision.
So in person loses that. If you do a broad one, you have a broader register.
So I don't think that in person necessarily loses that. So to address that point, even if the court were to assume just for purposes of this case that the definition of register in Section 4 carries through to Sections 5 and 19 when we're talking about other jurisdictions, I think the key is that we have to ask what is the requirement in the other jurisdiction, not what the requirement is for someone in Indiana. Let's talk about that.
In your response to transfer at page 16, this is what you say, quote, Peters might not have to update his information personally in Florida while living and remaining in Indiana. And you stand by that statement?
Yes, Your Honor.
All right. Isn't that a fatal flaw to a textualist reading of the statute? You're admitting he didn't have to go back.
Well, I think there's a difference between a registration requirement that exists in that state and whether it requires present action.
But we're looking at, so in Indiana, it's either 72, depending on the offense, or 7 days. You've got a duty to register if you're substantially similar or the other jurisdiction, right? So we're looking at that time frame. That's when you got to go to the sheriff's office and sign up, correct?
Well, I don't think it's you look at when the person is sort of the last day of the reporting period in Indiana.
I'm saying, so you're in the law in Indiana is when are you required to register? You're required to register either 72 hours or 7 days under our statute.
That's the latest date, but the requirement to register attaches as soon as a sex offender enters the state with the intent of residing, going to school, or working here.
Okay. But then you're in violation if you don't. So when you are required to register in person within 72 hours or 7 days, depending on which offense you had, correct?
Correct. And I think that your question gets to the difference between the existence of a requirement and whether that requirement requires current action. So to give maybe a more familiar example.
But I feel like that's a fatal flaw to your argument. You acknowledge that he has no ongoing obligation to register in person.
He's not facing circumstances that would require him to update his registration in person in Florida right now, but the requirement under Florida law still exists to maintain it.
Let me ask the same hypothetical that I asked her, because I said get ready for this, right? All right, so under the state's argument of a broad reading of register, not the narrow one that that's in there and Justice Slaughter talked about. If you are ever a sex offender in Indiana and you go to vacations, let's say your requirement ended 10 years ago, and you go to Florida on vacation, you still have to register, correct?
That's correct.
They use a past tense.
That's correct.
So once you leave Florida, no matter what state you go to, you've got to register for life, even though your offense is over. You no longer have an active.
Or at least in states that have.
Can Florida
other
say you off
jurisdictions.
because you visited here and you're registered for life? To maintain a registry, you also have a $100 fee per year to pay to stay on the registry, even though you don't come back to Florida? Is there a constitutional argument there?
Well, I think that could potentially be more tenuous. There's certainly, if we're talking about extraterritorial regulation, there's not necessarily a bright line.
So,
as we know from minimum contacts cases, Commerce Clause cases, that can be somewhat messy. But I think for what's important here is that to this day, he will have to take particular actions in Florida flowing from his original entry into that state.
But even Florida Department of Law Enforcement has an FAQ page. It says sexual offender predators are required to register with a temporary address in Florida, are subject to all Florida registration laws while the offender/predator is residing in Indiana. Then I look at that's what they're saying, and I get that's not law. I mean, we're saying that's what they say in the FAQ. But then when I read the statute on defining a sexual offender, it again has this place requirement. A sex offender is a person who establishes or maintains a residence, or student. I mean, there's other ones.
So there's two ways. There's a couple of different ways to qualify as a sex offender. One is in Florida, and this is under the statute we're all reading, subsection 1, where it says, if you committed a Florida offense or a similar offense in another state. It doesn't mean that another state has required you to register. And so just by virtue of his Illinois conviction, Peters would qualify as a sex offender in Florida who's required to register for life, whether or not Indiana, Illinois, or any other state ever required him to register.
Because of the past offense.
Right. And then if he were to return to Florida, he would have obligations that someone who had never before set foot in Florida does not have. For example, if Peters tomorrow were to say he's becoming a digital nomad, he's buying a camper van, and he's traveling to Florida, the Florida provision that says if you abandon your permanent residence and don't establish a new one would require him to register within 48 hours of entering the state. Now, a sex offender who had never before stepped foot in Florida would not be required to show up at a sheriff's office until they had been there at least 3 days, meeting the definition of establishing permanent, temporary, or other residence within that state. So, or similarly, if Peters were to buy a vehicle in Florida, he'd have to show up within 48 hours to report his new vehicle. Someone who wasn't already registered would not have that obligation.
Mr. Barr, I'm going to go back to my section, harping on Section 4. Help me if you would, please. I understand the state's position. I think there's a lot to it. I'm having problems squaring your position with what the text says. And I guess I'd ask you to, is there any case law that you're familiar with, either from our court or from a different court, that says you ignore a statutory definition of a term and instead rely on a general language definition of a term if, for example, in context it seems that the legislature couldn't have meant what they actually said? Is there anything from our court that you're aware of that stands for that?
Well, Your Honor, I think generally the principle of ordinary meaning sort of does inform, even when we're applying statutory definitions, that we have to make sure that that fits within the context. And certainly this court has cases saying that if it's clear that the legislature couldn't have meant this, and
that's the absurdity. I mean
that's
Court of
absurdity.
Appeals thrown around absurdity the other way. Are you using it? Is that what you're trying to get us to do for the state's position?
No, I don't think so, Your Honor. But I think that the biggest difference is this court has been clear that if there's a longstanding interpretation endorsed by the other branches and the courts, that we don't lightly presume that the legislature.
You're invoking legislative acquiescence?
Well, I think it's acquiescence plus the fact that this court's ex post facto cases rest on the understanding that the, quote, plain language.
But that wasn't even litigated in those other cases. The only question before the court in those cases was, is the presence on a registry a punishment for which there's an ex post facto issue? And we said there's not, but we didn't dig into the weeds of what that section says. I mean, do you agree with me that what the legislature probably intended to say was, as used in Section 8, register means the following?
It's something like that, Your Honor. But I think when we're looking at it, register in another jurisdiction, we can't sort of pair those two sections of the phrase apart. We have to look at what the other jurisdiction involves. And I think
would it blow up the statute? Would it blow up 5B1 if we were to interpret register throughout the chapter as it's defined in Section 4?
Well, I think that would mean anyone who leaves the former state of residence could say, we no longer have a requirement to report in person to that state. And so, therefore...
That's substantially similar. I mean, that's not the catch-all. If they're substantially similar, you're working there, you're school, you own some property there, there's still a lot of other ways to hook them into that other state.
That's correct, Your Honor, but it's then hard to see what purpose is Section 5B serving if it's not adding something to the substantially similar requirement.
But your answer it seems to me is focusing on is as opposed to focusing on register.
Well, I think if that reading is not textually satisfactory, let me propose one alternative.
Before you do, let me just ask you to maybe address something I'm concerned with, and I think we're losing sight of the fact this is really designed to protect people from bad conduct. And so whether we're talking about Virginia or we're talking about Florida, the issue is this conduct, a sex offense that happened in a state or a jurisdiction that meted out punishment. And I think that our statute, and I think that any version of SORA is really concerned about the reporting requirement for that specific conduct. And so I think that what we're having trouble with is a tangential problem of the offender moves or takes a very brief visit to another jurisdiction, and then we're adding upon that the requirements of a state that really had nothing to do with enforcement of SORA, particularly in this case where you've just got a vacation. I mean, why? How do you glom on all of that requirement? I understand why Florida might want to do that. Everybody there goes to vacation. Maybe you're going to engage in bad conduct that you wouldn't ordinarily, whatever the reason is for having people report and then having it there forever. What we're concerned with, I think, is that conduct in Illinois. And once he's satisfied that, he's certainly not required to do anything in Florida. He's not there anymore. I mean, are we just supposed to ignore that? Help me understand that. I know we're talking a lot about the text. It seems to me it's unclear. We've had different panels of the Court of Appeals come out differently, but aren't we just losing sight of the conduct? Why don't we just look at the conduct, which is what the legislature clearly told us to do, and decide what that reporting requirement is? If the General Assembly wants to change that, they can give us a big, long reporting requirement just like Florida has, but they haven't done that. And so that's my struggle.
So, Your Honor, I think one of the reasons the other jurisdiction provision exists, and it's certainly not the only reason, is precisely to protect people from bad conduct. When, around the time this was enacted, there were highly publicized reports from the federal government saying about 20% of offenders nationwide had escaped registration due to loopholes in state systems. And we know from looking across the country, one of the ways loopholes can be created is different states define their offenses differently. So if we're just trying to apply the substantially similar provision, there's a potential that truly dangerous offenders from another state won't be captured by it. And so that's part of the sense of enacting these other jurisdiction provisions that say, don't look to the particular conduct, just look to the
How does that happen here? How does that happen? I read the brief, I understand that, but you've got this guy that comes over and he not only reports here, as he was ordered to do, but he goes and reports in Florida. I have a hard time figuring out how he'd get caught not reporting in Florida if he's down there for a week's vacation. But he did. And he's served out the sentence and the reporting requirement from the state of Illinois. So how does that make us a safe haven if we're not going to say, yeah, Florida gets to decide this forever because he was there for 3 days?
Well, I think one reason is Peters has not articulated a principle that would allow this court to say someone like him is not required to register, but someone who committed an offense in Florida and comes to Indiana, is still required to register.
Well, they would be, wouldn't they? I mean, of course they would be. What I'm having trouble with is he's only on the radar because he went to Florida for 3 days. It has nothing to do with his conduct in Illinois.
Well, I think to the extent Your Honor is concerned about the fairness of that, I think the legislature has considered that situation and said it's not unfair.
I'm concerned about making sense of this. It just doesn't make sense to me that we would allow the reporting requirements in a state that had nothing to do with this, other than he was there for 3 days to govern the whole administrative process of the Department of Corrections. It just doesn't make any sense to me, and county sheriffs for that matter.
Well, I think in addition to the reason we talked about of eliminating loopholes, I think another reason the legislature had for that is administrative simplicity. Another is to ensure that citizens of Indiana have the same degree of protections of citizens of other states. And if we're looking at if we're concerned about the potential fairness of someone who travels for a short time, I think it's worth noting that the Indiana legislature has seen nothing wrong with requiring people from other states who spend 7 days here within a 6-month period to register. So someone who comes for 7 football games may now be required to register for 10, 25 years or life.
Mr. Barter, before your time expires, you brushed aside the federal constitutional issue before, but that's not so easily brushed aside for me. Can you address that a little bit more directly? It seems simple to me that Florida cannot impose any regulations on people that no longer have any connection to their state. And you mentioned personal jurisdiction can be messy. It can sometimes, but this is federal due process. It seems to me it would just explode our federal system if every state could regulate everybody for all of time if they ever passed through that state just once.
Right. So I think for all of time could certainly raise some difficulties, but we do know past conduct can give rise to some continuing obligations. For example, someone who spends part of the year here, earns some income, still has to file a tax return at the end of the year with Indiana, even if they move to Texas or Florida before the tax deadline rolls around. But to address one other...
But here you're saying it is a lifetime... You're saying it's a lifetime obligation and that the Constitution permits Florida to regulate somebody for the rest of their life, even though they have no connection to the state.
It's a lifetime obligation within Florida. Florida hasn't chosen to require current action while someone is outside of the state.
Because it can't.
Well, I don't think it's decided not to test those boundaries. But I think even if this court were to take the most restrictive possible reading, which is, I think would have to be something like someone has a foot in 2 states at once, Peters satisfies that requirement. On page 45 of the appendix, where it reflects that in 2018, while he was a resident of Indiana, permanent resident with ongoing reporting requirements, he was also required to register as a sex offender in Florida. So that would be one of those situations where someone has requirements to 2 states at once. And I don't think there's any constitutional difficulty with that, any more than there is for both Indiana and Illinois to pose requirements on someone who works in one state and lives in another.
Can you help me understand how he's not required to do this for all time because he passed through Florida, when it's my understanding that his requirement to continue to register in Indiana is based entirely on his brief visit in the state of Florida?
You can go ahead and answer that even though your time's up.
So that's correct, Your Honor, but the obligation in Florida is an obligation that exists in Florida. I think this gets back to what I mentioned at the beginning, the difference between the existence of a requirement and one requiring present action. So to give an example that may be more familiar, Judicial Code of Conduct requires judges to be honest and cooperate with disciplinary tribunals. Now, a judge may go her whole career without ever having to interact with one of these disciplinary agencies, but that doesn't mean the judge isn't under a duty to cooperate and be honest, and I think the same is true here. Someone who has a lifetime obligation in Florida within that state is under reporting requirements that would require action if they're back in that state, but don't while they're absent from that state.
Thank you, Mr. Barta. Ms. Winnicke, rebuttal.
May it please the court. I want to address, Justice Slaughter, your question about the definition of register. You know, it's not only that the legislature has defined it, it's defined it right in the act. I don't think that we can ignore it. And it has a particular meaning, as you said. It's to report in person and to report the certain information. And so Mr. Peters does not have to return to Florida every 6 months or whatever their law is to report in person. He does not have to register current in Florida. The reason they haven't come to get him is because they can't. He does not fit the definition of sex offender right now because he's not in Florida. And so he doesn't have a present obligation. The fact that he's up on their registry is completely different. They treat their registry as if it's sort of a public criminal history, their online registry. We here in Indiana treat it sort of part and parcel with the obligation to register. If you consider it a hypothetical, if I understand the state's argument, if Mr. Peters were to decide next week he wants to go to Vegas for a week, from what I understand, even before he gets there, if he knows he's going to go, the state is going to say, okay, when you get there, now because you've, touched grass in Las Vegas, you have to register for the rest of your life. And that would be true of 49 other states, anywhere that he goes. The purpose of the other jurisdiction provision is to not allow Indiana to be a safe haven where people were coming here for relief from their requirements. It was never meant to force registrants to never leave the state for any reason for fear of having to register.
So what's left? I mean, so if it's not a substantially similar crime, and under the hyper-technical definition of to register, who's covered if you don't own property, go to school, have a job here? Because there's other things that are in the other jurisdiction requirements. Who's covered?
Well, Mr. Tyson, I think, is a perfect example. He had to register because of a Texas conviction, or I think it was a delinquency adjudication, and we would not have made him we wouldn't have made him register here in Indiana, but he had that requirement. And so we, as part of receiving federal funding to comply with certain guidelines, we have in our law that when he comes here and lives, he has to register.
But under your argument, he only has that requirement when he's in Texas.
No, under my argument, that the registration requirements attached to his delinquency adjudication under Texas law. So it's similar. It's not a sentence, but it's like a sentence. And so the question is, where does he register? So if he leaves Texas, he can register here in Indiana, and that fulfills that requirement that he has. But that requirement's attached to the conviction. It's not the mere fact that he's in the state itself. That just tells him where to register. It doesn't create a brand new obligation.
So whatever your registration requirement is, if you come to Indiana under the other jurisdiction, that hangs with you, because that's part of what you call it the collateral consequence of your original registration.
Yes, and it's attached to the conviction. And
so if you had, let's say they had the type of offense that would be a lifetime registry, but they only got 10 out of the year that they're doing. So they moved to Indiana. Do they have the lifetime under Indiana now? Because that's how we define the type of sexual predator. Or are we limited to the lesser registration requirement from the sending state?
And are you asking, in your hypothetical, does subsection A apply, like are substantially similar imposes a life?
No, other jurisdiction.
The person would have a lifetime requirement if it's attached to the collateral consequence of the conviction, yes. So if Mr. Peters had committed his offense in Kentucky, for example, or Florida, that has a lifetime requirement, that lifetime requirement would carry over.
Do you share my impression that if Section 4 means what it says, register means register as narrowly defined in Section 5B1, that would essentially blow up 5B1? In other words, who would qualify as an other jurisdiction registrant, given that definition in Section 4?
Well, a way to explain this would be to use a hypothetical. Let's say that you have an offender who has a registration obligation in Indiana, but he moves to Syria or something that doesn't have a sex offender registry. Does that relieve him of the obligation? No, he still has to register because there's a requirement attached to the conviction. So what does he do? He can continue registering in Indiana, just report his Syria address. He can register with the federal registry. We do have that option as well, and people overseas do that. Thank you.
Well, counsel, well-argued, brief case. We appreciate it. We will be discussing the case with the first issue will be whether we grant transfer. Thank you.
All right. Court is adjourned.